of parties. The provisions of the Code of Civil Procedure are based on a general principle that as far as possible, no proceeding in a court of law should be conducted to the detriment of any party in his absence. Order 9 of the Code enacts the law with regard to the appearance of and non-appearance of parties and the consequences thereof. 1 and 12. Okay. Rule 1 requires the parties to attend the court in person or through their pleaders on the day fixed in the summons for the defendant to appear. Rule 12 provides that where plaintiff or a defendant who has been ordered to appear in person does not appear in person or show sufficient cause for non-appearance, the court may dismiss the suit if he is a plaintiff or proceed ex parte if he is the defendant. అంటే ఎవడైతే రాలేదో వాడి కర్మ అంటే బొక్క కొడతాం. That is where neither party appears. Rule 3. Where neither plaintiff nor the defendant appears when the suit is called out for hearing, the court may dismiss it. The dismissal of the suit under Rule 3, however, does not bar a fresh suit in respect of the same cause of action. The plaintiff may also apply for an order to set aside such dismissal, and if the court is satisfied that there was sufficient cause for his non-appearance, it shall pass an order setting aside the dismissal of the suit and shall fix a day for proceeding with the suit. Where only plaintiffs appear, Rule 6 and 10. Where the plaintiff appears and the defendant does not appear, the plaintiff has to prove service of summons on the defendant. If the service of summons is proved, the court may proceed ex parte against the defendant and may pass a decree in favor of the plaintiff if the plaintiff proves his case. The provision, however, is confined to first hearing and does not per se apply to subsequent hearings. Where there are two or more plaintiffs and one or more of them appear and others do not appear, the court may permit the suit to proceed as if all the plaintiffs are appeared, or make such an order as it thinks fit. Where only defendant appears, Rule 7 and 11. Where the defendant appears and the plaintiff does not appear, the defendant does not admit the plaintiff's claim wholly or partly, the court shall pass an order dismissing the suit. But if the defendant admits the plaintiff's claim as a whole or a part thereof, the court will pass a decree against the defendant upon such admission and dismiss the suit for the rest of the claim. It may be noted that this rule, Rule 8, will apply to a case where there is only one plaintiff and he does not remain present, or there are two or more plaintiffs and all of them remain absent. When there are more plaintiffs than one and one or more of them appear, Rule 10 will apply. It is, however, a serious matter to dismiss the plaintiff's suit without hearing him, and that course ought not to be adopted unless the court is really satisfied that the justice so requires. But the court has no power to dismiss the suit where the plaintiff does not appear owing to death. Such an order is a nullity inasmuch as this rule applies to the defaulter and not to a dead man. Rule 9 precludes the plaintiff thereafter from filing a fresh suit on the same cause of action. He may, however, apply for an order to set aside the order of dismissal, and if the court is satisfied that there was sufficient cause for his non-appearance, the court may set aside the order of dismissal and fix a day for proceeding with the suit. In deciding whether a suit dismissed for default be restored, what is really to be considered as to whether the plaintiff was really trying to appear on the day fixed. If he honestly intended to appear though in a stupid way, he should not be deprived of hearing if sufficient cause is shown by the plaintiff for his non-appearance. Reopening is mandatory, but when sufficient cause is not shown, it is directory. What is sufficient cause depends upon the facts and circumstances of each case, and liberal and generous construction should be adopted. Appearance and non-appearance of parties. To advance the cause of justice and restoration should not ordinarily be denied. Where a party against whom an order is made appears on the same day and prays for recalling of an order, normally the prayer should be granted by the court. In Chotalal versus Ambalal Hargovan, the High Court of Bombay observed that when a party arrives late and finds that his suit or application is dismissed, he is entitled to have his suit or application restored on payment of costs. In a subsequent case in Karimbhai versus Ninich Moose, same High Court held that it would be difficult to agree with Chotalal in principle as a proposition of law. If such a rigid rule is laid down, it may mean that the defendant could successfully prevent his suit ever being heard, and all that he would have to do would be to able to appear late on successive dates and allow the suit to be heard ex parte and then apply at the end of each day to have the suit restored for hearing. That obviously is a course which no court would allow. It is submitted that the latter view is correct. Before such order is passed by the court, notice must be served on the opposite party. When there are two or more defendants and one or more of them appear, and the others do not appear, the suit will proceed, and in the time of pronouncement of the judgment, the court may make such an order to the absent defendants as it thinks fit. In such a case, a decree may be contested as one against some of the defendants and ex parte against the rest. What the court has adjourned the hearing of the suit ex parte, the defendant at or before such hearing appears and assigns good cause for his previous non-appearance. Court may hear him upon such terms as it directs as to the cost and otherwise. In that case, the defendant might have the earliest proceedings recalled. set the clock back and have the suit heard in his presence. On the other hand, he might fail to show good cause. Even in such a case, he is not penalized in the sense of being forbidden to take part in the further proceedings of the suit or whatever might still remain of the trial. Only he cannot claim to be relegated to the position that he occupied at the commencement of the trial. The underlying principle is that until the suit is finally decided, the defendant has a right to come in and defend the suit. This rule, therefore, should be liberally construed. Where summons are not served, rules 2 and 5. It is a fundamental rule of law of procedure that a party must have a fair and reasonable opportunity to represent his case. And for that purpose, he must have a notice of the legal proceedings initiated against him. The service of summons on the defendant is therefore a condition precedent to a fair trial. If the summons is not served on the defendant and does not give him sufficient time to represent his case effectively, no decree can be passed against him. Rule 2 of Order 9 enacts that the suit may be dismissed when the summons is not served on the plaintiff's failure to pay costs for service of summons to the defendant or to present copies of the plaint. No such order, however, can be passed in spite of such failure by the plaintiff if the defendant appears in person or by his authorized agent on the day fixed for him to appear. The plaintiff may file a fresh suit even after the dismissal of the suit under Rule 2 in respect of the same cause of action, or may apply for an order to set aside such dismissal. And if the court is satisfied that there was sufficient cause for such failure, the court shall set aside such order of dismissal and shall fix a day for proceeding with the trial. Where the plaintiff fails to apply for a fresh summons for 7 days after the summons on the defendant or one of the defendants, where there are 2 more defendants, is returned unserved, the court will dismiss the suit as against the defendants or such defendants. But if within that period the plaintiff satisfies the court that he has failed, in spite of his best efforts, to discover the residence of the defendant who has not been served, or such defendant is avoiding the service of process, or that there is any other sufficient cause for extension of time, the court may extend the time for such period as it thinks fit. If the suit of the plaintiff is dismissed by the court within the period of limitation, he can file a fresh suit also. While it is not proved that the summons is duly served on the defendant, the court will direct a fresh summons to be issued and served on the defendant. Where it is proved that summons is duly served on the defendant but there was not sufficient time to enable him to appear and answer on the day fixed on the summons, the court shall postpone the hearing of the suit to a future day and give notice of such a day to the defendant. Where the summons is not duly served or is not served in sufficient time due to the plaintiff's default, the court shall order the plaintiff to pay the costs occasioned by such postponement. Ex parte decree. Meaning, an ex parte decree is a decree passed in the absence of the defendant in absentia, where the plaintiff appears and the defendant does not appear when such suit is called out for hearing, and if the defendant is duly served, the court may hear the suit ex parte and pass a decree against him. Such a decree is neither null and void nor inoperative, but is merely voidable. And unless and until it is annulled on legal and valid grounds, it is proper, lawful, operative, enforceable like a bipartite decree, and it has all the force of a valid decree. Remedies. The defendant against whom ex parte decree has been passed has the following remedies available to him. 1. To apply to the court by which such decree is passed to set it aside, Order 9, Rule 13, or to prefer an appeal against such decree, Section 96, Clause 2, or to file a revision under Section 115 where no appeal lies. 3. To apply for a review, Orders 47, Rule 1, or to file a suit on the ground of fraud. The above remedies are concurrent and they can be prosecuted simultaneously and concurrently. Where 2 proceedings or 2 remedies are provided by a statute, one of them must not be taken as operating in derogation of the other. Where 2 proceedings or 2 remedies are provided by a statute, one of them should not be taken as operating in derogation of the other. Setting aside ex parte decree, Rule 13, who may apply? The defendant against whom ex parte decree has been passed may apply for setting it aside. Where there are 2 or more defendants, any one or more of them may also make such application. The expression defendant is wide enough to include a person who is adversely affected by the decree. A purchaser of mortgage property hence may make an application under Order 9, Rule 13 of the Code. But a defendant against whom the suit has been dismissed cannot be said to be aggrieved by the decree and cannot apply under this rule. Where application lies, an application for setting aside ex parte decree may be made to the court which passed the decree. Where such decree is confirmed, reversed, or modified by a superior court, an application may be filed in a superior court grounds. This rule requires an application by the defendant to set aside an ex parte decree passed against him if there exists sufficient grounds for it. If the defendant satisfies the court that if the summons was not duly served, he was prevented by any sufficient cause from appearing when the suit was called out for hearing, the court will set aside the decree passed against him and appoint a day for proceeding with the suit. Summons not duly served. As provided under Rule 6, the suit may proceed ex parte against the defendant only when it is proved by the plaintiff to the satisfaction of the court that the defendant did not appear even though summons was duly served. In that case, an ex parte decree may be passed against him. Therefore, if the defendant satisfies the court that the summons was not duly served upon him, the court must set aside the ex parte decree passed against him. Sufficient cause. The expression sufficient cause has not been defined anywhere in the code. It is a question to be determined in the facts and circumstances of each case. The word sufficient cause must be liberally construed to enable the court to exercise powers ex debito justitiae. A party should not be deprived of hearing unless there has been something equivalent to misconduct or a gross negligence on his part. Necessary materials should be placed on record to show that the applicant was diligent and vigilant. Improper advice of the advocate may be a good ground to set aside ex parte decree, but it cannot be accepted as sufficient cause in all cases. Whether or not it was sufficient cause would depend upon facts and circumstances of the case. If there are delaying tactics and non-cooperation on the part of the party, he cannot seek indulgence of the court. Where the lower court declines to allow ex parte decree to be set aside, Supreme Court will not interfere with such order. The test to be applied is whether the party honestly intended to remain present at the hearing of the suit, or it is best to do so. Good cause and sufficient cause distinction. There is no material difference between the two expressions, good cause and sufficient cause. Grounds, whether exhaustive. The language of the rule is plain, express and unambiguous, and the grounds mentioned therein are exhaustive. Material date. Material date for deciding sufficient cause for non-appearance by the defendant is the date on which ex parte decree was passed, and not his previous negligence or past defaults. In G.P. Srivastava versus R.K. Raizada, Supreme Court stated, sufficient cause for non-appearance refers to the date on which the absence was made a ground for proceeding ex parte and cannot be stretched to rely upon other circumstances anterior in time. If sufficient cause is made out for non-appearance of the defendant on the date fixed for hearing when ex parte proceedings initiated against him, he cannot be penalized for his previous negligence which had been overlooked and thereby condoned earlier. Government defaulting party. The word sufficient cause cannot be construed differently merely because the defaulting party is a government or an instrumentality of the state. Such interpretation would violate doctrine of equality enshrined in Article 14 of the Constitution. But ground realities of life also cannot be ignored. Whereas a private individual takes a decision one way or the other almost instantaneously, a democratic government or a bureaucratic department hesitates and halts, discusses, debates, considers, consults, peeps through papers and files, speaks through notes and drafts, moves horizontally, vertically, till at last it gravitates towards a conclusion, unmindful and oblivious of urgency and emergency. Power and duty of court. When an application for setting aside ex parte decree is made by the defendant, the court should consider whether the defendant was prevented by sufficient cause from appearing before the court when the suit was called out for hearing. If the court finds there was sufficient cause for non-appearance, it is bound to be set aside the decree. Conversely, if sufficient cause is not shown, ex parte decree cannot be set aside. The right in this duty is a sine qua non of judicial procedure. An order setting aside ex parte decree is judicial. It must be supported by reasons. Test. The test which should be applied is whether the defendant honestly and sincerely intended to remain present when the suit was called on for hearing, and it is best to do so. If the reply is in the affirmative, ex parte decree should be set aside, but it is in the negative, ex parte decree cannot be recalled. Precedents. Sufficient cause is a question of fact. Each case has to be decided on the facts and circumstances before the court and not on precedents. Irregularity in service of summons effect. The second provision as added by the Amendment Act 76, however, lays down that the court shall not set aside ex parte decree merely on the ground of irregularity in service of summons in a case where the defendant had adequate notice of the date of hearing of the suit and had sufficient time to appear and answer the plaintiff's claim. The court thus makes distinction between illegality and irregularity. The illegality and irregularity, the former goes to the root of the matter and the renders into the action null and void. Irregularity, the latter, however, does not invalidate the action unless prejudice has been caused to the person making a complaint. The word "and" in the second provision to Rule 13 must be read as conjunctive and not disjunctive. Hence, unless both the conditions are satisfied, an ex parte decree cannot be set aside. Burden of proof. The burden of proof that there was sufficient cause for non-appearance is on the defendant, but it is enough if he proves that he attempted to remain present when the suit was called on for hearing. There may be many proceedings in a court wherein his personal appearance may not be necessary. Sufficient cause. Illustrative cases. Following causes have been held to be sufficient for the absence of the defendant. 1. Bona fide mistake as to the date of hearing. Late arrival of a train. Sickness of a counsel. Fraud of opposite party. Mistake of a pleader in noting wrong date in a diary. Negligence of the next friend or guardian in case of minor plaintiff or defendant. Death or relative of a party. Imprisonment of the party. Strike of advocates. No instruction is persists by a lawyer. No sufficient cause. And that's the illustrative cases. Following causes, on the other hand, have been held not to be sufficient for absence of a defendant for setting aside an ex parte decree. 1. Dilatory tactics, bald statement of noting wrong date in a diary, negligence of party, counsel busy in other court, suit of higher valuation, Absence of defendant after prayer for adjournment is refused. Hardship of defendant. Absence to get undue advantage. Mere thinking that the case will not be called out. Not taking part in proceedings. Limitation. An application for setting aside ex parte decree can be made within 30 days from the date of the decree. Notice to opposite party. An ex parte decree cannot be set aside without issuing notice to the opposite party and without giving him an opportunity of hearing. This is in consonance with the principles of natural justice and fair play procedure. An application under Rule 13 for setting aside an ex parte decree may be made by the defendant. In case of death of a defendant, his legal representative can also make such application. It should be signed and verified by the party and not by his advocate, upon such terms as the court thinks fit. The court has a very wide discretion in imposing such terms on the defendant as it thinks fit before setting aside the ex parte decree. It may order the payment of costs and may order the defendant even to deposit the decretal amount in the court in an appropriate case. The discretion, however, must be exercised reasonably and judicially, and not arbitrarily and capriciously. If the terms are onerous and otherwise unreasonable, the superior court can interfere with them. When an ex parte decree is set aside on certain conditions and those conditions are not complied with within the time granted by the court, the application stands dismissed. Imposition of conditions. While setting aside ex parte decree, court has wide discretion to impose appropriate conditions on the defendant. The court has a very wide discretion in imposing such terms on the defendant as it thinks fit before setting aside the ex parte decree. It may order the payment of costs or may order the defendant even to deposit the decretal amount in the court in an appropriate case. The discretion, however, must be exercised reasonably and judiciously, not arbitrarily and capriciously. If the terms are onerous or otherwise unreasonable, superior court can interfere with them. When an ex parte decree is set aside on certain conditions and those conditions are complied with within the time granted by the court, the application stands dismissed. Inherent power to set aside decrees. Since the court makes specific provision for setting aside ex parte decree, no inherent power can be exercised to set aside such a decree. As Rankin stated, I entirely dissent from the view that if no case is made out under the Rule 13, it is open to the learned judge to enlarge the rule by talking about Section 151, res judicata, where an application for setting aside an ex parte decree is dismissed. No fresh application would lie if such dismissal is on merits, and the rule of res judicata will apply. But if the dismissal is for default of the appearance or circumstances has been changed, a second application would be maintainable. Successive applications are maintainable only if circumstances have changed, not otherwise. Execution of decree effect. The fact that an ex parte decree has been executed does not disentitle the defendant from applying under Rule 13 to get it set aside. If the decree is set aside, restitution can be ordered. Decree satisfied. Effects. The extent of setting aside ex parte decree. A peculiar situation, however, arises when ex parte decree is passed against all the defendants, but summons are not served to all of them, or an application to set it aside is made by some of them. However, against some of the defendants, a decree is passed on merits after hearing them, but against some of the defendants, it is passed ex parte, and the application to set it aside is made by one or more of the defendants against whom a decree is passed ex parte. As a general rule, the court will set aside the decree only against such defendant or defendants who made an application. Illustration. In a suit by A against B, C and D, an ex parte decree was passed. C and D were not served with summonses while B was served. In an application by C and D, it was held that the decree against B cannot be set aside. The proviso, however, makes it clear that there is a decree of such a nature that it cannot be set aside as against the defendant only. The court may set it aside against the other defendants also. In the following class of cases, the are co-partners of a joint Hindu family. They jointly execute a mortgage in favor of X. X files a suit against all of them. Summonses is served to C but not to A and B. None of them appears and ex parte decree is passed against all. A and B applied to set aside the ex parte decree. Here the decree being one and indivisible, it ought to be set aside against C also, where the suit would result in two inconsistent decrees if the decree was not set aside against the other defendant also. X sues A and B, joint executors of a promissory note, but the recovery of the amount due thereunder. As a matter of fact, B has paid the amount due to X. Summons is served to A alone. None of them appears and an ex parte decree is passed against both. B applies to set aside the decree. Decree must be set aside against A also. The reason is that if B succeeds in proving the payment, there will be two inconsistent decrees, where the relief to which the applicant is entitled cannot effectively be given otherwise than by setting aside or decree against the other defendants also. Illustration. A files a suit against B, C and D on a mortgage bond and gets an ex parte decree against all of them. B alone applies to set it aside, neither in the mortgage nor in the plain nor in the decree. There is any specification of shares or liabilities of the respective defendant. Decree must be set aside as a whole, where the decree proceeds on a ground common to all of the defendants. A sues B and C on a promissory note. B is a principal debtor and C is the surety. An ex parte decree is passed against both. B alone applies to set aside the decree and shows sufficient cause for his absence. Decree must be set aside against C in also inasmuch as the liability of both is based on a common ground. Effect of setting aside ex parte decree. The effect of setting aside an ex parte decree is that the suit is restored, and the court should proceed to decide the suit as it stood before the decree. The trial should commence de novo, and the evidence that had been recorded in the ex parte proceedings should not be taken into account. Hearing of the application pending appeal. Mere filing of an appeal and appellate suit against an ex parte decree does not take away the jurisdiction of the trial court to entertain and decide an application for setting aside an ex parte decree order under Order 9, Rule 13. As already stated earlier, two proceedings are different, distinct and independent, and there is no possibility of conflict of decision. Dismissal of appeal against ex parte decree. Where an appeal against an ex parte decree has been decided on any ground other than the withdrawal of such appeal, an application to set aside such ex parte decree does not lie. Appeal. An appeal lies against an order rejecting the application to set aside ex parte decree. As stated above, an ex parte decree is a decree under Section 2, Clause 2 of the Code. And therefore, an aggrieved party can also file an appeal under Section 96(2) of the Code. A controversial and somewhat complicated question of law is whether in such cases the appellate court can only consider decree passed by the lower court on merits as to whether there were sufficient grounds to pass the decree, or whether the appellate court can also consider whether there were sufficient reasons for the defendant for non-appearance and the court was not justified in passing an ex parte decree against the defendant. There is a conflict of judicial decision on this point. One view is that the appellate court can consider only the question whether the decree was wrong in law, while the other view is that appellate court has the power to consider whether the lower court was justified in proceeding with the matter ex parte, and if the lower court was not right in doing so to set aside the ex parte decree, it is submitted that the latter view appears to be much more acceptable and preferable, particularly when appeal is continuation of the suit and rehearing of the matter, revision. An order setting aside an ex parte decree is a case decided within the meaning of Section 115 of the Code and is therefore revisable. A High Court may also exercise supervisory jurisdiction under Article 227 of the Constitution in appropriate cases. Review. Since all the remedies against an ex parte decree are concurrent, an aggrieved party can also file an application for review of the conditions laid down in Order Rule 1 are satisfied. Suit. A suit to set aside an ex parte decree is not maintainable, but if an ex parte decree is alleged to have been obtained by the plaintiff by fraud, the defendant can file a regular suit to set aside such decree. It is a settled law that fraud vitiates the most solemn transactions. In such suits, the onus is on the party who alleges that the ex parte decree passed against him was fraudulent.